Good afternoon. It's a great pleasure to be invited by Professor Marcus Mueller-Chang to present on the common law, specifically the English legal system, for this comparative law seminar at the University of St. Gallen. My name is Professor Mimi Zhou. I hold joint appointments at the University of Exeter and the University of Oxford in the United Kingdom. I'm very sorry I can't be in St. Gallen this afternoon in person. I do very much hope to be there in person in the near future and meet all of you. And of course, you're more than welcome to visit England, and I'll leave my contact details at the end of this seminar. So I've been invited to give an overview of the key aspects of the English legal system. I'm going to focus today more on case law, recognizing that an important source of the English legal system is also legislation. So without further ado, let me just present the structure of today's presentation. I'm going to start with the key characteristics of English law. Then I will go on to explain the concept of parliamentary sovereignty, which really is a fundamental concept in English legal system. Then I'll go through various sources of English law, ranging from customs, the common law, equity, legislation, and a little bit about the influence of European Union law, which of course has, it has certainly formally not have any influence from this point onwards, given Britain's departure from the European Union. And finally, what's very important to understand is that the English legal system is very much predicated on a formal hierarchy of courts. And I'll go through various courts in some detail towards the end of this lecture. So to start with, the key aspects of English law, there are quite a few dimensions, but just the key ones that I want to emphasize is, first of all, and we will talk about parliamentary sovereignty in a second, is that Parliament makes law, and many of the laws that I teach my student in commercial, contract, tort, even in areas of private law, statute plays an important role. Of course, in the area of public law, statutes very much have a central role in the English legal system. Judges, of course, also make law, and we will explore some key concepts such as the system of precedence in this lecture. And what's important to understand that English law isn't codified. So if we look at private law systems in continental Europe, there usually is some sort of civil code. If we look at codified public law instruments, well, England doesn't quite have a single constitution in the way that, for example, Germany has and other European countries. So it's fair to say that English law, there's no concept of this single-fied, unified code that may be a marker of other systems, whether it's in private law or in public law. And in the English legal system, when it comes to going to court, many of you may recognize that it is a much more adversarial trial system where the two parties are engaged in arguments to try and convince the adjudicator that their arguments are stronger on the balance of things in the case of civil cases. So it's not an inquisitorial system that we might find in many civil law jurisdictions, where the court's role is more to inquire into which side of the story is one that is more believable. In the English system, it's certainly a much more adversarial trial system than in civil law systems. So that's kind of a few of the key features of English law. So let me start by explaining a little bit more about the idea of parliamentary sovereignty. This is absolutely critical to understanding the English legal system. It's a principle of UK constitution, and I'm going to go and talk a little bit about the relationship between parliamentary sovereignty and the UK constitution in the next slide. But essentially, what the idea of parliamentary sovereignty is that Parliament is the supreme legal authority in the UK. So Parliament can create, or they can also abolish any law. Unlike the United States, and this is why it's interesting to talk about the differences between different common law jurisdictions, because in England, the courts do not exercise the same sort of power and authority that the US Supreme Court has, which is to overrule legislation. This is something that is just not seen in the English legal system because of the primacy of the concept of parliamentary sovereignty. Courts in general cannot overrule legislation by Parliament. And so even future parliaments can change the law. It's not bound by any laws that have been passed by its predecessor. This is a really crucial part of understanding the UK constitutional law system. Now, many countries have adopted some sort of unified documentary constitution, this complete constitution that, with articles covering a range of rights and obligations and details about the relationship of different state government agents or institutions, the relationship between the government and the citizen. Now, in the UK, there isn't one such written constitution. So in many sense, it is a little bit abstract. Okay, so some people say the UK doesn't have a written constitution, but that's technically not true, because UK constitution can be said to be consisting of various laws passed by Parliament, as well as practices and conventions that have evolved over a long period of time. So you can say that it's partly written and definitely wholly uncodified. That is, it doesn't exist in a single code. It comes from many different sources. Okay, so that's just some background to the concept of constitution in the UK context. Now, I just refer back to Dicey just because I think what he has to say about the idea of parliamentary sovereignty as the underlying principle in the English legal system is really crucial. So essentially, just provide the quote here, the principle of parliamentary sovereignty means neither more or less than this, namely that Parliament has, under the English Constitution, the right to make any law whatever, and further, that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. Okay, so this is Dicey's view of parliamentary sovereignty, which has influenced so many features of the English legal system. Parliament can legislate on any matter. Parliament can even change its own authority its own powers. So Parliament, basically, the new Parliament is not bound by the laws of the previous parliaments. So it can change any law at any time. And we saw this, of course, in the context of Brexit, when the UK Parliament, under a Conservative government, decided that it will hold a referendum and essentially pursue the outcome of that referendum, which was to renounce the membership of the United Kingdom from the European Union, which was actually enacted in Parliament in 1972 when the UK joined the European Union. So that act has been repealed. As I've said, it's very important under the principle of parliamentary sovereignty that the acts of Parliament cannot be overruled by any limb of government. Okay, so that is absolutely crucial to understanding the limits of the courts in the UK compared to, for example, the US. Now, of course, there are always limitations, and the limitations on the authority of Parliament included a few. And certainly before Brexit, European Union law was actually superior to UK Parliament when it came to matters that were covered by EU law. Of course, that was a bone of contention, as we say, a thorny issue when it came to the debate about Brexit that took place in the United Kingdom over the lead up to the Brexit referendum. So there are a number of examples where UK Parliament, prior to Brexit, had to accept the supremacy of EU law when it came to issues and matters that were covered under EU law. Of course, that has changed since Brexit, and EU law no longer is the supreme authority on matters covered by EU law for the UK. Okay, so that limitation on the authority of UK Parliament has been removed post-Brexit. There is an important limitation that remains on UK parliamentary authority, and that is the European Convention on Human Rights, to which the UK still remains a signatory. Okay, so essentially the acts of Parliament should still be comparable with the ECHR. Okay, of course, we know that any act of Parliament, because the UK is a member and a signatory to the ECHR, it can be challenged. A statute of the UK Parliament can be challenged if it is not compatible with the European Convention on Human Rights. Now, the implementation of the ECHR in the UK is contained in the Human Rights Act. Okay, and the Human Rights Act, basically, the courts can actually declare that an act is incompatible with the Human Rights Act, which implemented the ECHR. However, it does not mean that Parliament has to change the law. Okay, again, parliamentary sovereignty rules supreme. Okay, so even though the ECHR and its domestic implementation in the UK Human Rights Act is a limitation, however, the Human Rights Act makes it clear that Parliament does not have to change the law. Usually, though, it does. Okay, it doesn't look very good from a PR perspective that the Human Rights Act has been contravened by another legislation. And so usually the UK Parliament will go and change the offensive provisions of the legislation if it was found to be incompatible with the ECHR. So we now turn to the second part of this lecture, which is on the sources of law. So it could be said that there are four main sources of law, although some don't play a major role in the English legal system today. So if we start with, let me just give you an overview of the four main types. We have customs, we have case law, we have primary legislation, acts of parliament. We also have what's called delegated legislation, which I'll go into more detail later on. And of course, European law, European Union law, has had an influence on the English legal system for the past few decades. And notwithstanding Brexit, many principles of EU law, of course, have played an important role in shaping particular aspects of English law. But let's start with customs, which is the earliest form of lawmaking in the English legal system, and really the basis of common law. So following the conquest, the Norman conquest in 1066, judges would travel the country making decisions on behalf of the king. Now, these judges based many of their decisions on customs. What was the common custom of the land at the time? So custom now plays a very small role in modern English law. Its main use is really where there's a local traditional practice. So, for example, where local fishermen dry their nets on a particular piece of land, or villagers holding a fair in a particular place. It's rarely used as a source of law these days, because essentially most customs are now established in case precedent, which is a separate source. This is where we talk about the common law. So we will talk about the concept of precedent in more detail in a second, but essentially common law can be seen as an organized system of law that began in 1066, where people sorted out their disputes in a certain way before these traveling judges around the country. And so before the system of common law, the disputes would be resolved in different ways. Okay, so this obviously brought a lot of uncertainty, unpredictability, and in many ways, you could say that the procedures or the outcomes were unfair. Okay, so the dispute resolution mechanisms were different in different parts of the country. And so with common law, the idea was for King William to have judges that traveled around the country to resolve people's disputes and make decisions in his name with the central court in London. Okay, so it was a centralized system that was trying to unify the way that disputes were being resolved throughout the country. These judges who went on behalf of King William went around in set circuits or areas. So this idea of circuit judge is still being used today in the English legal system. And these judges, these traveling judges, agreed among themselves the best way of resolving disputes. and applying the law. And as such, they built up a system that they all followed to establish consistent treatment of all citizens. And this became the common law. The law was the same for everyone across the land. So these judges would apply the law according to these established rules that they agreed on. And they had also been looking at how previous cases have been decided, and they followed these cases. And so this is known as the doctrine of stare decisis, a really fundamental principle of the common law. And in this way, as the law developed through this common law system, the whole idea was that it would become consistent, fairer, and more predictable. Okay, so by 1250, okay, from 1066 to 1250, what we have seen in England is the establishment of a common law system that ruled the whole country. It's also known as case law, or judicial precedent, or stare decisis. So let's talk a little bit more about this concept of judicial precedent. Okay, so this is absolutely fundamental to the common law system. So this is not just in the English common law system, but also around the world. In the discussion, we can talk a bit more about the differences between different common law systems, but the whole idea of precedent is that the past decisions of the courts would create this case law, which will be followed and applied in similar factual scenarios in future cases and also by lower courts. Stare decisis, it's Latin, and essentially the idea, the meaning of the concept is that you have to stand by what has been decided and do not settle what has been established. Okay, so this is really crucial to the system of judicial precedent as a source of law, whereby the past decisions of the judges create law for future judges to follow, and suddenly the decisions of higher courts bind those lower in the hierarchy of courts. And there is an effective system of reporting cases. The whole system is there to ensure consistency and predictability, and ultimately fairness. So for precedent to work, there has to be a court hierarchy. And I'll cover the hierarchy of courts in the English legal system in the final part of this lecture. So essentially, when you decide a case as a judge in the English legal system, you must first establish what the facts are. So what exactly happened? And then secondly, how does the law apply to these facts? And it's a second task. How does the law apply to the facts that creates the case law? So once a decision has been made on how the law applies on that particular set of facts, then the idea is that similar cases must be treated in the same way. The whole concept of stare decisis. So when you look at an English court judgment, essentially it's structured in this way. First, a summary of the facts. Then the judge will review the legal arguments from both sides. Then the judge will give a lot of commentary. Sometimes the judge may not give commentary just relevant to the case. They could also go into explaining what the legal principles are upon which the judgment is made. Okay, so you can get some judgments that are, well, maybe not like textbooks of that particular legal principle, but very much a very detailed explanation of that legal principle relevant to the case. And then finally, the case is recorded. Sorry. So another very important concept that you would have come across for those of you who may have looked into the common law system is the concept of ratio decidendi, which is the decision, the reason for the decision. It is not, so it's not the decision itself, ratio decidendi. It is the reason for the decision. Okay, so the legal reason for making the decision. And essentially, it's been defined as any rule expressly or impliedly treated by the judge as a necessary step in reaching his conclusion. Okay? And this is the ratio that creates the precedent for future judges to follow in similar cases. And sometimes it's not very easy to identify the ratio decidendi. Now, there are actually different types of precedents. Okay, so just briefly, the three main types are binding precedent, original precedent, and persuasive precedent. So binding precedent is exactly what it is. Okay, a precedent from an earlier case that must be followed. Okay, even if you're the judge, you're in a case that's got a similar factual scenario, you have to follow this binding precedent, even if you do not agree with the precedent. Okay, that's the whole point of stare decisis. And so that's binding precedent is a precedent from an earlier case, which must be followed. Now, an original precedent is where you have a case and there is a new point of law that has not been decided before. So that is then that case, that ratio decidendi for that case, for that decision, will be the original precedent. Okay, so this is the new precedent, essentially, in a case where that point of law has not been decided by previous cases. And so, basically these days, it's probably hard for the court to come up with an original precedent, just because the English common law system has evolved over centuries, and there usually is not a point of law that hasn't been addressed in a particular case. And then finally, there is what we call a persuasive precedent. Okay, so there are scenarios where a judge might not be bound by a particular decision, but they may choose to follow it nevertheless. Okay, so for example, courts lower in the hierarchy, they are usually not creating the precedents. The precedents are usually created at the higher level by the Supreme Court, or it was formerly known as the House of Lords, or the Court of Appeals. Most precedents for most point of laws come from these higher judicial bodies. So sometimes, though, you might come across a case where the Court of Appeal, the Supreme Court, looks at cases that have emerged from courts, from lower courts, and they say, actually, that's a pretty good or comparable reason for this decision to apply in my case. So it's not a binding precedent because higher courts are not bound by decisions of lower courts. But the judge in the higher court, in some instances, may decide to pick up a decision from a lower court. And in such a scenario, that's what's known as a persuasive precedent. It's not binding, but it's persuasive. And that can be quite common. So, what can judges do with precedents? Now, you think that they must always follow, and yes, that tends to be the case, that they generally should follow the precedent, the binding precedent from an earlier case, if that case is has similar facts, very similar facts to the facts of the case before the judge, then yeah, the idea is that you follow the precedent. So for lower courts, they should always, almost always follow the decisions of the higher court. And in many instances, they also follow the decisions of their own courts. So a Court of Appeal judge should be following the decisions, the precedents at the Court of Appeal, and of course the Supreme Court, which is the higher court. Of course, there are some instances, very limited instances, where judges, particularly those from higher courts, can overrule its own decisions. Okay, so this is where it's a bit less likely, but certainly you do see instances where the Supreme Court overrules its own decisions. Now, the Supreme Court is not necessarily bound by its early decisions, but basically it's very good practice for the Supreme Court to follow its own decisions. The Supreme Court has developed a mechanism for it not to follow its own decisions, and that's what's known as the practice statement. So the practice statement was a mechanism created by the Supreme Court in 1966 that basically stated that in some circumstances where it appears right to do so, that they can actually depart from its previous decisions, even though they should really be following that particular precedent. Okay, so for example, a case where the Supreme Court applied the practice statement was in the case of Pepper and Hart in 1993. And the issue, the point of law in that case was whether the Hansard, which is a collection of materials that documents the parliamentary debate when a bill has been proposed and debated in Parliament. Now, prior to that case, the Supreme Court in an older case stated that actually Hansard should not be used as a statutory interpretation aid. Then in 1993, this Pepper case, essentially the Supreme Court applied the practice statement and said actually it's right, it appears right to do so, to actually overrule this previous decision and hold that the Hansard can be used as an aid for interpreting statutes. So this is where it is quite rare, but certainly it does very much happen in certainly cases of appeal, where essentially a superior court changes the outcome of a case from a lower court based on the same law. Okay, so I say it rarely happens. It probably does happen more often, but I do think that there is also, lower courts. They do communicate with each other, so it really is not as common. I would say that in most of the cases, and I've practiced as a litigator before, the lower courts are very cautious, right, to apply binding precedents. So in the occasional case, you will see that the higher courts basically reverse the lower court's decisions and say, nope, they've got the facts wrong, or no, they've got the point of law wrong, and therefore, or they just, they just haven't understood the precedent properly, and so the higher courts can reverse the decisions of lower courts. Of course, another way of actually avoiding precedents in a particular case, is actually to distinguish the binding precedent from the current case. So you can say as a judge, look, the facts of this case are actually significantly different from the facts of the supposed binding precedent. And that way, it is one way where you can avoid the application of the binding precedent. Okay, so you can very much say the facts of the case are different here, or you can say actually the point of law in this case is actually different to the point of law that was the basis of the decision in a previous case. And so distinguishing the current case from the previous case, the supposed precedent, is often a way that judges distinguish, basically avoid what would be otherwise a binding precedent. So we know that the common law developed after the Norman conquest, with judges traveling around the country to sort out disputes, and in the process, the common law developed. Now, there are some disputes that needed solutions that could not be found in the common set of rules. So the king and his judges came across these disputes where they felt they could not bring justice to the situation. For example, in such a case, a man may be complaining that his neighbor was using his land as a shortcut, and all common law could do was to offer the man, to require his neighbor to pay the man in compensation, that is, damages, under common set of rules. But what the man wanted was for the neighbor to stop using his land as a shortcut, to stop this behavior. So common law could not provide fairness in situations like this. And this is where the law of equity or fairness developed alongside the common law. So that this body of principles, court equity, developed alongside the common law when it was considered fair and appropriate to do so. So at first, the king would hand these difficult cases to his chancellor, not the judges, but to his chancellor, who was a religious figure and not legally trained. And the chancellor could depart from the common law to pass an equitable judgment in those types of disputes where fairness was required and where the common law rules were too rigid to provide a fair outcome. So the chancellor, in overhearing these cases and delivering a judgment in equity, was also known as the king's conscience. He had his own discretion, and when it was fair in the circumstances to depart from the strict common law, he would do so. So the important thing is that in equity, the claimant must come to equity with clean hands. So they must not have done anything wrong. Otherwise, equity will not be applied to them. So what has happened to equity is that it has emerged as a body of strict rules and principles like the common law over time. And it has very much developed its own precedents. And so what started as applying to cases where common set of rules under common law should not be applied due to considerations of fairness has today evolved to become a quite rigid body of rules itself. And so it is a bit ironic, but that's how the English law of equity has evolved. So the other important source of English law is legislation. I've already explained the importance of parliamentary sovereignty. And so acts of parliament really are the supreme sources of the law in England. And it could be divided into two types of legislation. Primary legislation being the acts of parliament, where parliament passes legislation that provides the provisions regulating different areas, a certain matter or issue. Then there is what's known as secondary legislation. And so secondary legislation has been passed by Parliament, so Parliament has given its authority, but usually it's to another body to make the more detailed provisions. So, for example, Parliament may authorize through a legislation a certain minister to make more specific statutory instruments related to this particular topic. Okay, so Parliament grants authority to another body to make the more detailed provisions. The same as what's known as local bylaws, where Parliament grants authority to local authorities, local councils, to make more specific rules regarding matters that relate to their own local area. So those are examples of secondary legislation. Now, the final source of English law is EU law, and that arises from the UK's membership of the European Union for several decades. For actually, this year marks the 40th decade of the 50th decade of the membership of the UK in the European Union. And so essentially with Brexit, EU law no longer has any authority. New laws have no authority in interpreting English law. Obviously the Court of Justice of the European Union decisions on points of EU law are no longer binding on the courts of the UK. But it is important to note that because of UK's long-standing membership in the European Union, EU law has actually influenced many aspects of UK law. But certainly any new law in the EU now will certainly have no force and application to the UK. So finally, we reached the hierarchy of courts in England and Wales, and I think I'll just go through quickly the various courts in this hierarchy, starting with the Supreme Court, also known as the House of Lords, then is followed by the Court of Appeals. The Court of Appeal has two divisions, the Criminal Division and also the Civil Division. Following that, there is the High Court. The High Court deals with civil decisions mostly, and also the Crown Court. And the Crown Court is really for the more serious criminal cases where a jury trial is involved. Now, the lowest courts in this hierarchy are the Magistrates' Court, the county courts, and the family courts. And those courts, basically they really are they're on the coalface of the English court system. And most cases have to start with these lower courts before they proceed to the higher courts. There's also, I should mention, tribunals. There are tribunals set up in the UK in recent decades in certain areas such as employment and immigration. And the purpose of tribunals is to simplify procedures and provide basically cheaper and more accessible ways for people to access justice. So in terms of how precedent works, it really relies on this hierarchy of courts, starting from the Supreme Court, where the Supreme Court's decisions really binds all other courts in the hierarchy. And then the Court of Appeal, the second level, now the Court of Appeal binds other lower courts. Of course, it doesn't bind the Supreme Court, but the Court of Appeal usually also binds itself. There are some exceptions which are made in the case of Young and Bristol Airplane, a particular case relating to certain exceptions where the Court of Appeals can depart from its own decisions. We won't have time to go into that today. And then divisional courts, so higher courts, bind everything below it, including themselves. And then basically when we go below, like High Court, Crown Courts, County and Magistrates Court, essentially there's not many scope room left for precedents to be developed. And so these lower courts generally don't create precedents. But on some procedural matters, for example, the Crown Court can bind Magistrates Court, which is below them in the hierarchy. So you can see that in terms of the system precedents, the most important courts are the Supreme Court and the Court of Appeal and the divisional courts. And then the lower courts really have fewer roles. And the tribunals have even fewer role, a smaller role in terms of creation of precedents. As I've said, they've been set up to provide more simplified procedures and cheaper access to justice in areas such as employment, immigration, and social security. I've provided some websites for finding case law for those of you who are doing comparative research projects involving finding case law from either the English legal system or other legal systems in the common law jurisdictions. This is really just for English case law, but I'm happy also to talk about other databases for common law jurisdictions. So that's all from me, and very much look forward now to Q&A and a broader discussion about either the English legal system. Of course, I haven't been able to cover all the issues, so if there's any questions you may have about any aspect, I'll be very happy to answer. We can also talk about other common law systems that you may be interested in. Thank you very much for having me, and yeah, looking forward to your questions.